The Constitution of India guarantees certain fundamental rights to the citizens of India. The 42nd Amendment to the Constitution introduced a chapter on the fundamental duties of the Indian citizens. Various disputes might arise between the government and the citizens regarding the implementation of the rights and duties. In order to resolve these constitutional disputes, the court competent to deal with such cases must be there. The Supreme Court and the state high courts have been established to deal with all such problems and other cases of civil and criminal in nature. The judicial system in India. The judiciary is the third organ of the union government. All the courts at the different level in a country put together are called judiciary. In a federal system, division of powers between center and the state is essential. Since there is a division of powers, it is possible that disputes might arise between the center and the state governments and among the state themselves regarding their powers and functions. The judicial system of India has been organized like a pyramid as a single integrated unit. At the apex of the pyramid, there is a Supreme Court of India. Next to it are the high courts of the states. At the lower level, there are district courts and other subordinate courts. Appeals against the decisions of a lower court can be made to the court immediately above it. The Supreme Court, the apex court in India. We have single unified judiciary in India. The Supreme Court is the apex court of India. All other courts in India, example, all the high courts in the 29 states, the courts at the district and the subdivision level are under the Supreme Court. All these courts form a part of a single integrated judicial system in our country. Our Supreme Court is the highest court of our country. It is located at New Delhi. It consists of a Chief Justice and other judges. The Chief Justice and other judges of Supreme Court are appointed by President of India. Qualification. A judge of Supreme Court should have certain qualification in order to be a judge of Supreme Court of India. The first one, they must be a citizens of India. Second one, they must either be advocates of a high court or the two or more high courts for at least 10 years, or they must be a judges of high courts of 5 years standing. The third one, they are distinguished jurists in the sight of, in the opinion of President of India. Distinguished mean well known. They are a well known jurist in the sight or in the opinion of the President of India. The judges of Supreme Court retire at the age of 65. They once appointed, they cannot be normally removed from their service before the age of retirement. A difficult method has been specified in our constitution for the removal of the judges from their office. It is called impeachment. They can only removed from the service if the Parliament of India passes a resolution by the two-third majority requesting the President to remove the particular judge of being guilty of misconduct. Powers of the Supreme Court. The Supreme Court has three kinds of powers to pass the judgment in civil and criminal cases in India. The first one, original jurisdiction. Second one, appellate jurisdiction. And third one, advisory jurisdiction. And this Supreme Court also will act as a guardian of Constitution, especially the fundamental rights. Also, this Supreme Court will be called as a court of record. Original jurisdiction. The Supreme Court has the original jurisdiction. It means the authority to hear the cases directly for the first time, which extends to the following cases. The first one, the cases between the Government of India and one or more states. The second one, the cases between the Government of India and one or more states on one side and one or more states on the other. The third one, the cases between the two or more states. The fourth case, the interpretation of the Constitution in the case of dispute between one or more states or interstate relating to the some justiciable right, including the fundamental right also. The last one, to decide the constitutional validity of the union laws, which means that if any question arises regarding the union laws, that problem will be solved by, it should be solved by Supreme Court of India directly in the first instance. Appellate jurisdiction. The Supreme Court is the highest court of appeal. It has a very vast appellate jurisdiction. The Supreme Court can hear the cases of appeal from the High Court, Civil Court, and the criminal courts of the district. Advisory jurisdiction. The President may seek Supreme Court for opinion or advice on a question of law or a fact which is the public importance in the opinion of the President. The Supreme Court may give its opinion, but the opinion of the Supreme Court is not binding on the President of India. Revisory jurisdiction. The Supreme Court has the power to review any judgment or order passed by the Supreme Court. And this, the provision is made by our Constitution of India in order to rectify the error or mistake was made by the Supreme Court of India. Guardian of the Constitution. The Supreme Court is the guardian of the Constitution. It decides all the cases which involve any point of the constitutional law. Thus, the Supreme Court acts as an interpreter for our Constitution of India. It can declare our laws made by Parliament or State Assembly as invalid if those are found to be against our Constitution of India. And the Supreme Court also can issue the writs for the safeguarding or for the enforcement of the fundamental rights. Court of Record. The Supreme Court is a court of record in India. This means that all the decisions of this court are recorded and published. These decisions are cited in the lower courts in various cases. The judgments of the Supreme Court are treated as a law by the lower courts all over the country. Also, it has the power to punish anyone for its contempt.